number is 422-300-3161. Firstly, I will explain about the analysis and summary. The analysis of this case is about the termination of the claimant's employment due to allegation of assaulting a subordinate who is known as Mabubo, a cleaner that is employed by the company. Firstly, background. In November 2014, the claimant began working for the company as a site supervisor and was later promoted to Executive 1. In August 2020, he was suspended awaiting an inquiry following charges of workplace violence against Mabubo, which resulted in his dismissal. Secondly, domestic inquiry, or known as DI. The company conducted a DI on August 17, 2020, during which the claimant was accused of beating or assaulting Mabubo on two consecutive occasions, which is one at Tesco Puchong and the second one is at IREL City Mall. The DI panel condemned the claimant based on the evidence given. Thirdly, a dispute over DI attendance. The claimant denied attending the DI on August 17, 2020, claiming that he returned to work on August 21, 2020. After his suspension expired, however, the company presented documentation such as minute and a DI report showing the claimant present. Next, witnesses including Mabubo and other employees testified that the claimant assaulted Mabubo. Mabubo also filed a police report about the alleged attack. The court deemed the company's testimony reliable and consistent. In addition, violation of duty. As a supervisor, the claimant was obligated to safeguard and ensure the well-being of subordinates. By hitting Mabubo, he broke this obligation and committed significant wrongdoing. The court emphasized that physical violence or aggressiveness in the workplace is never acceptable. Therefore, dismissal with just cause. Based on the fact offered and the gravity of the wrongdoing, the court determined that the claimant's dismissal was appropriate. The claimant conducts damaged faith in his capacity to carry out his responsibilities properly. Last but not least, legal precedent. The court highlighted an identical case in which a supervisor assaulted a foreign worker, upholding the assumption that such misbehavior requires dismissal in order to promote workplace harmony and respect for all employees. In conclusion, the court rejected the claimant's lawsuit against the company, determining that he was fired for fair due to his misbehavior. The summary of this case is about a disagreement between the claimant, who was previously employed by the company, and the company itself. The claimant began working for the company as a site supervisor and was subsequently promoted to Executive 1. However, on August 4, 2020, the claimant was suspended awaiting an inquiry following charges of workplace violence against a worker under his supervision, which is Rahman Muhammad Mabubo. Mabubo is a cleaner for the company who is being accused by the claimant of attacking him twice, once at Tesco Mall in Puchong and again at IREL City Mall in Putrajaya. On August 17, 2020, a domestic investigation was performed and the claimant was found guilty of assault. The company then terminated the claimant's employment on August 24, 2020, then claiming significant inappropriate behavior as its justification for dismissal. The claimant challenged the termination and requested reinstatement through representation to the Director General for Industrial Relations, which resulted in the case being submitted to the Industrial Court for judgment. During the trial, the company called 6 witnesses to support its case, including people who observed the suspected assault and those involved in the domestic investigation. However, the claimant merely testified in his own defense. The crucial question before the court was whether the claimant attacked Mabubo, which was claimed by the company. Despite the claimant's denial and declaration that no domestic inquiry was conducted on August 17, 2020, the court found overwhelming evidence, including witness testimony and documentary evidence, to support the company claim that the domestic inquiry did take place and that the claimant was present. After reviewing the evidence given, the court determined that the company had effectively shown on the balance of probability that the claimant attacked Mabubo, thereby breaking his duty of protection and decent treatment as a supervisor. The court emphasized that physical violence or aggressiveness in the workplace should not be condoned, and that all employees, including foreign workers, are entitled to be treated with dignity. Finally, the court found in support of the company, finding that the claimant dismissal had been proper due to his significant misbehavior. As a result, the claimant action against the company was rejected. So that is all from me.
Hello, my name is IREL and I will talk about the fact or issue of this case. First issue of the case between Paul Benjimen and PWB Silva has alleged assault and misconduct. The main focus of this case is the accusation that the claimant and employees who work as operation executive one physically abused Mahbubo, a subordinate. Second issue of the case between Paul Benjimen and PWB Silva is domestic investigation and dismissal. The domestic inquiry DI that the company carried out on 17 August 2020 to look into the claims of assault against the claimant is the key event in the case. Lastly, the issue of the case between Paul Benjimen and PWB Silva is a burden of proof and industrial courts evaluations. The important idea of the burden of proof and industrial courts subsequent assessment are at the heart of the current case.
Hi, my name is Nariwani. So I will talk about related case of law. Employment contract it governs the connection between the firm and the claimant. Promotion and confirmation. The claimant was promoted inside the corporation, suggesting a step up his work standing. Notice of suspicion and domestic inquiry correct protocol. The corporation issue as a notice suspicion and conducted a domestic inquiry into alleged misbehavior. Dismissal for misbehavior. They claim a job was terminated due to finding a gross misbehavior, especially attacking a subordinate. Burden of proof or standard of proof. The burden of proof lies with the employer to demonstrate the alleged misconduct occurred. Duty of care of workplace safety. Duty to ensure the safety and well-being of its employee, including the protection from workplace violence. Next is related case of act. The court weighed numerous considerations while deciding the case, including whether the claim assault it happened and if it was fair cause for termination. The court determined that there was sufficient evidence to prove that the employee assaulted the subordinate. The court determined that the employee action were substantial misbehavior and deserved firing. So next I will talk about pros and cons about this case. First, for pros is fair adjudication, and second is protection of workers. Third is legal precedent. For cons is first is unavailability of key witness. Second is reliance on company evidence, and last is lack of independence.
Solution to the case in order to overcome the issue from repeating in the future for organizations. First solution of the case in order to overcome the issue is improve courses of study. In order to address the balanced differences in the employees' behavior and stop such events in the future, enhance training program and essential. Second solution of the case in order to overcome the issue is strict enforcement of the workplace. To ensure a safe and continuous work environment requires strict adherence to workplace standard. Third solution is frequent inspection and assessment. In order to maintain a safe and healthy work environment, require protective measures including conducting audit and regular monitoring of workplace behavior. Lastly, the solution of the case is periodic evaluation of performance. The company needs a strategic approach that can have many positive effects on organization and incorporate evaluation of supervisor performance with a particular emphasis on their management and leadership ability in routine performance review.